Your visa application has been refused by IRCC. You believe there is a mistake and you want to overturn the refusal to be accepted. In today's video, we're going to talk about your various options and strategies. My name is Cedric Marin. I'm an immigration lawyer at Hulf Immigration Law. We're going to talk about how to make a request for reconsideration, whether or not judicial review is appropriate, when to reapply for the application, and whether you can make an appeal at the Immigration and Refugee Board. In the second part of the video, we're going to talk about strategies, right? Can you make the reconsideration at the same time that you reapply and at the same time that you make an application for judicial review? Stick with me, and today we're going to talk all about these various options. Let's start with reconsideration requests. What is a reconsideration request? A reconsideration request is a letter that you write to IRCC to explain why you believe there is a mistake. There is no specific form and there's no specific way to do it. You're going to be submitting your reconsideration request by web form. However, here are the most important parts for the reconsideration request. First and foremost, explain what you want as the desired outcome, whether it's reopening your application, continue processing, and having an acceptance. Have the desired outcome at the very top of the letter. Number two, focus on the factual issues. If the visa officer made a mistake in facts, made a mistake with your family composition, with your settlement funds, with your experience, explain why there's the mistake. What evidence did you provide in your original application that the visa officer did not consider, right? Why is this factual finding by the visa officer a mistake? Number three, explain the error of law. Do you believe that the IRCC officer made a mistake by applying the law? What are the requirements of the work permit application or the study permit application? Where do you find them? Provide them in your letter and clearly explain why you believe there is a mistake that took place. You might also want to include the various rules and regulations attached to your letter to make it very easy for the visa officer to read your letter, read the law, and realize they made a mistake. Lastly, make sure that you're always respectful to the visa officers. They're going to be the ones making the final decision. You might be upset with how long it took for the processing. You might be upset with the refusal, but being respectful goes a very long way in making an application. If you're serious about making your own reconsideration requests, take a look at the link in the description. I wrote a very detailed blog that has a step-by-step guide about how to prepare your own reconsideration requests, what to do before and after. A judicial review is a formal court process. You are going to court arguing IRCC has made a mistake or the decision is unreasonable. IRCC is going to be represented by a lawyer at the Department of Justice, and you are asking a judge for an order to overturn the refusal and have another officer make the decision. This means that if you are successful at the federal court, your application is returned to IRCC. It does not mean that your application will be approved. It is very important to note that you have 15 days to start an application for judicial review from the date of the decision if you are inside Canada, and for decision of outside Canada, you have 60 days to make an application for judicial reviews. It can be an expensive process in terms of legal fees because it is very time consuming to do legal research, memorandums of argument. It can take more than 6 to 12 months before you receive a decision from the court. A lawyer will typically try to reach a settlement with IRCC to minimize costs and processing times for the application. But you need to know that when you start the application, you need to then obtain leave from the federal court. 80% of applications, 80% of applications are rejected at the leave stage for immigration cases. If you are rejected at the leave stage, there is no appeal. You cannot continue your judicial review. If you are accepted at leave, you will then go on to have a hearing and a decision by a judge. It is recommended to have a lawyer to go to the federal court, but it is not required. The court process can be complicated and there can be a lot of laws and litigation and specific rules that apply when you make a judicial review. Now, The third option is reapplying. You've already been rejected, and can you reapply? Absolutely. Usually, if none of the circumstances have changed, we usually recommend that you don't reapply. If you're going to be submitting the exact same application, you might be getting the exact same response. This being said, if your application was rejected since it was incomplete, you may want to reapply and provide the complete application. In some cases as well, you can consider adding more documents to overcome the reasons for refusals. For example, in a study permit application, your letter from the designated learning institute, your letter of acceptance, might have deficiencies in it, right? It might not be a proper letter. In this case, you might want to get new documents to support your application. Reapplying can be shorter in terms of processing times compared to a judicial review. It is a more formal process compared to a reconsideration, and you know the test that has to be met. You know what you need to provide and what to do to reapply. And again, it really depends on your case. As another example, if you have committed a misrepresentation because you did not disclose previous criminal convictions, in that case, reapplying for a study permit or work permit is not going to have any effect because you've already committed the misrepresentation. But it is a valid option not to forget about. You're able to reapply for your immigration application. The fourth option is to the Immigration and Refugee Board. You need to know that they have very limited jurisdiction in some cases. A sponsorship appeal that is from outside Canada, an appeal for a removal order, a residency obligation appeal, it's very specific cases. If you have an appeal at the Immigration and Refugee Board, you have to do so before going to the federal court. But again, just very specific cases that you have a recourse at the Immigration and Refugee Board. All right, let's talk strategy. So you've been refused a study permit application, you've been refused a visitor visa, you've been refused permanent residence. Well, let's go through our options again. Right? The reconsideration is informal. It's free. You submit it by web form. You explain why there's a mistake that have been made. Maybe you'll get a decision, maybe not. Maybe it's going to take a few weeks to process. It might take a few months, but it's an inexpensive option that is available, and it can lead to your refusal being overturned and your application being accepted. At the very same time, you might consider reapplying, right? If it's an incomplete application, as we talked about, you can go ahead and get the missing documents, fix the issues in your documents, and reapply. So on one hand, you have the reconsideration request for the previous application saying, please open my application, right? Please continue processing. Look at this mistake that you've made. At the same time, you can have a second application pending and make a new application. Now, in terms of judicial review, as we talked about, it can take 6 to 12 months before you receive a decision. It can be an expensive process. Even if we're successful, it doesn't necessarily guarantee that your application is going to get accepted. But in some cases, if you faced multiple refusals, the reconsideration requests are not fruitful, judicial review may be your only option, right? Again, 15 days, 1-5. If you're inside Canada, and 60 days if if the decision is outside of Canada. So these are your options. Some individuals will choose to do all three. Make the reconsideration requests at the same time, start an application for judicial review, and at the same time, reapply and trying to fix whatever error has been made by IRCC in a new application. So all three options are valid in terms of what you want to do, but it's really case dependent about whether or not how many refusals you face, your chance of success with the reconsiderations, how long the reconsideration request has been pending, and that delay at the federal court. If you are serious about a judicial review, we have a whole page here which I've taken the time to really explain the process. It's a very detailed explaining the whole process of a judicial review at the federal court. The link is inside the description. So there we have it. This is how you can overturn a decision by IRCC. We have the reconsideration request, the judicial review, reapplying, and as we talked about in some cases, you have an appeal at the Immigration and Refugee Board. In terms of strategy, you may want to do all three at the same time. I'd like to thank you so much for watching this video. My name is Cedric Marin. I'm an immigration lawyer at Holt Immigration Law. You can take a look here on our website. At the very bottom, here I am, Cedric Marin. Learn more about myself, my education. And if you'd like to speak with me at the very top, go speak with a lawyer. At the bottom here, you can find my areas of focus, including litigation, refused applications, reconsideration requests, mandamus applications. Click at the bottom here to speak with me. Thank you so much for your time. Bye.